Hello, everyone, and thank you for joining us this morning. Obviously, we've gathered virtually due to some tough and unexpected circumstances, but we plan to make the most of it this morning. My name is Amy Marquez. I'm the VP of Program Services and Events with the Lubbock Chamber of Commerce. Just a few housekeeping notes before we continue with our program. First, please let me remind you once again to keep your microphone muted throughout the duration of the meeting. Having an unmuted mic will cause feedback, echoes, and other sound interruptions, and will make things more difficult for attendees to hear clearly. We will have time for questions at the end of today's presentation. You can submit those via chat function of this meeting, or if you're calling in, you can email your questions to me at amy.marquez@lubbockbiz.org. That's amy.marquez@lubbockbiz.org. Please help me welcome Ann Manning. Ann is the managing shareholder of the Underwood Law Firm's Lubbock office. She is board certified in labor and employment law by the Texas State of Legal Specialization. Her primary concentration is in education, employment, health law, including civil litigation in these areas. She has been the president of the Texas Council of School Attorneys and on the board of directors of the school law section of the Texas State Bar. Ann has written and produced a children's Christmas musical, The Child is Born, produced 13 piano solo CDs, and plays a piano for her church. Her husband, Neville, and son, Jay Paul, are practicing attorneys in Lubbock. Her daughter, Julie Mitchell, is a middle school science teacher. Ann is blessed with 4 grandchildren. With that, welcome, Ann, and I'll turn it over to you.
Good morning. I wish I could see all of your faces, but since I can't, I'm looking forward to presenting this to you. You know, last Friday about this time, we heard Governor Abbott give his declaration, and this last week has been really difficult and an unknown situation that we haven't had before. With that in mind, I want to go through this Families First Act that has been enacted by Congress and signed by the President, and this will affect nearly every single one of you employers. So we'll start first. I'll do this one. I'm making sure I get my clicker correct, if it's working. Ron Garcia, our office attorney here, we're trying to get our clicker working, and it's not. Sorry for the technical delay. Can we press it here?
It's just working a second ago.
There we go. I don't know where you pressed. Okay, we're going to have 3 parts to this enactment, and we're dividing it basically on dates. So you're going to see the first one is going to be unpaid leave prior to April 1st. Things are changing so much, we thought it was April 2nd until yesterday. Now it's April 1st. So we are on the 27th, beginning next Wednesday, the unpaid leave portion will end. It will then merge into the Emergency Paid Sick Leave Act. And then after 80 hours or 2 weeks, it will go into the FMLA and an emergency expansion of that. So we're going to take one at a time. Out here. All right. From now until Wednesday, any leave that your employees take will be unpaid legally. You do not have to pay them during that time, and they may elect to substitute any PTO or other accrued leave for unpaid leave during this period. That does not mean you cannot pay them. You can pay them, but you will not be reimbursed under this act if you do. So from now until Tuesday, the leave will be unpaid. Now, I've had many questions from clients asking, can I lay employees off? I don't have anything for them to do and my business is closing. Yes, you may, but you need to do that before April 1st. The pay provisions of the Act do not apply during this time, and there are no qualifying events are triggered, and you don't have to pay them. You lay them off and they may file for unemployment. It is my understanding that with unemployment, we used to have a delay in gaining the unemployment, but now they are just immediately going ahead and getting money to the employees that have been laid off. One thing that you do need to know about the unemployment, you realize that that is going to go on your unemployment amounts that will have to be paid. And if it goes over a certain amount, you'll be required to pay that. So even though you lay them off, you may have some monetary liability for them filing for unemployment. Something else is the last one, laying off employees may disqualify your company from an SBA loan. So let's talk about the loans a little bit. Our government has really come to the forefront. We already have one loan that has been enacted, and it is the Economic Injury Disaster Loan, EIDL. And you can apply for this loan at this email address, disasterloan.sba.gov. Now, I do not know whether or not you're prohibited from getting this if you lay off your employees. I don't believe you're disqualified on this particular loan. The second loan is the CARES Act, and that's what has just been passed by both houses and is awaiting the president's signature. I don't know if that's been done yet. This one may really be phenomenal, especially for small businesses. You can apply for the loan, and then this loan may be forgiven, or a portion of it may be forgiven. And this is the one that we are not sure if you lay your employees off that you would be disqualified or not. So that is a question that we're just waiting to find out. And the third thing, it's a great day to be in Lubbock, Texas. The mayor has just had a press conference at 10 o'clock. And we have the CH Foundation, the Community Foundation, Helen Jones Foundation, United Way, and United Supermarkets, and they are all going together for money for mainly the mom and pop businesses that just thrive on everyone coming to their business. And they are going to have grant applications for you for loans from that group. So our people have really come together for you. So now this is everything up until the end of next Tuesday. Beginning Wednesday, on April 1st, the Emergency Paid Sick Leave Act goes into effect. And the covered employers are every employer with fewer than 500 employees. So I anticipate that all of you are included in this group. So this is going to be, the eligible employees will be all employees, no time differential that you may have, all employees except for healthcare providers and responders. Physicians mainly, that's what the regs are saying on the healthcare providers. Nurses would be eligible, but physicians would not. The qualifying reasons for this leave, they're in two separate groups. So we're going to take group one first. The employee is subject to a federal, state, or local quarantine or isolation order related to coronavirus. That would be our shelter in place, or that would be a quarantine that would be mandated. Two, the employee has been advised by a healthcare provider to self-quarantine due to coronavirus. Now that might be that they are so immune suppressed that they've got to self-quarantine, but the healthcare provider has to give that notice. And third, the employee is experiencing symptoms of coronavirus. So these are our very important group one So with that, you are to give them 80 hours of fully paid sick leave for full-time employees. Pro rata for part-time employees. So the part-time employees will be included if they fit into group 1. And then it's a maximum of $511 per day that would be reimbursed by the government to you for those employees, or $5,110 in the aggregate. So that is your group 1. Now remember on that, if we go back, it's if we're quarantined or we're shelter in place, or you have to self-quarantine, that's where that is applied. But it's only for 2 weeks. Now, group 2, an employee is caring for an individual subject to an order in group 1 that we just talked about, or has been advised to self-quarantine due to the coronavirus, because they're caring. Now, that's the care for reason. Number 5, the employee is unable to work or telework due to a need for leave to care for their child under the age of 18 where the school has been closed, or the child care provider of their child is unable due to the public health emergency. That is where so many of your employees are right now. Schools are closed. They may not be able to have child care at this time. They may not be able to work from home. And so they would be in group 2. And then number 6 is the employee is experiencing a similar condition to the coronavirus, which has been designated by HHS. Right now, we do not have that. So with group 2, the pay is different. The pay reimbursement is different. The 80 hours, it's partial. They get 2/3 of their normal wages, are required to get that, paid sick leave for full-time employees, pro rata partial sick leave for part-time employees, and then there's a maximum $200 per day or $2,000 in the aggregate that you will be reimbursed. Now realize you can pay more. That's the important thing. But know that you're only going to be reimbursed to this amount. So let's say you have very highly paid employees that are in this group 2. You may choose to allow them to use their PTO as a basis, or you can pay the whole amount, but you will only be reimbursed for this amount. Moving on. After the 2 weeks, and that 2 weeks, the 80 hours can be used at any time. It's just at the beginning of a leave. So if you have, let's say that you have an employee that has child care right now, and that child care is, the grandmother's not able to take care of them after about 4 weeks. So at the 4 weeks when they have to go home, that's when our emergency leave back here would come into play. And then it would start, the time starts after the 80 hours have been used. They can also use, it doesn't have to be 80 hours at one time. You might pay them, they might be able to come in 1 day a week. And so 4 days a week, you pay for that during the 80 hours. But after 80 hours has been exhausted, now we move to the Emergency Family and Medical Leave Expansion Act. And what this act does, it's amending the FMLA that we have, and it gives unpaid and paid leave taken between 4/1, next Wednesday, to when it sunsets December 31st. Now this is something that is going to probably concern many of you on its application. As you know, the FMLA is not required unless you have 50 employees. If you have 50 employees, you're under FMLA, and you have to give them 12 weeks of unpaid leave, and for certain reasons. Now, with this emergency FMLA, all of you, one employer up, is going to be under the FMLA. So those FMLA policies need to be policies. Don't panic completely. If you have 50 or less employees, you can ask for an exemption from the Department of Labor. So that is something that you will want to start applying for now. For the next 2 weeks from July, you have to implement this. So I understand that it will probably automatically, if you apply, there's no even now for that change. Public employers that are currently subject to the FMLA will also be under this new FMLA. All right, employees, we do have a time frame for employees. Yes, not under the Emergency Savings Act, but under the new FMLA, they have to work for you for at least 30 days. And your eligible providers of physician and emergency responders are not eligible. Okay, I'm getting notes. It's not coming through. Is that correct? Let's try to get the audio better. Cheryl, on the last 5 minutes, is that better? Something? It says still bad. Let's see if we can get something better here. Says, okay, clearing. Okay, I'm going to go back to the FMLA since so many of you could not hear it. So we're going to go back up a few slides. Okay. The Emergency Family and Medical Leave Expansion Act. Is that better? Okay. This is amending the FMLA. It's unpaid leave taken beginning next Wednesday forward. The covered employers are private employers with even fewer than 50 employees. So all employers are going to be required to be under this emergency FMLA. As you know, if you started this time, if you had 50 or less employees, the FMLA did not apply to you. Now it does. So this is in addition to, you will have an FMLA policy, and you have the amendments that we're going to speak about right now. The employers, the eligible employees, it's different than the Emergency Sick Leave Act. Under Emergency Sick Leave Act, remember I said everybody's going to be eligible. Not so for the FMLA. They had to have worked for you for at least 30 days. And the healthcare providers and emergency responders are not eligible. Okay, how's our sign? I'm hearing that we can't hear again. Do I have someone that can say if we're better?
And it seems to be quite a bit better, but you're still cutting out some.
All right. We will. I'm going to get a little closer and maybe that would be better.
And is it okay to ask questions during this?
I think Amy said that we'll ask questions at the end.
Gotcha. Sure. Okay. No problem.
Thank you so much.
Okay, here we go. The qualifying reasons for the leave. This is what they're adding to the FMLA. Remember, under FMLA, it's for pregnancy, it's for the birth of a child, it's for an adoption, it's for taking care of a son or daughter, a family member, or a serious health condition of an individual, plus military leave. Now this adds to those to care for a child under 18 years of age because the school or place of care has been closed, or the child care provider of their child is unavailable due to a public health emergency. Now that is the only addition for the qualifying reason. But what you will need to do is get an FMLA policy plus an emergency policy that will amend the FMLA during this time period. So what happens? Now this is where it gets a little confusing, so hopefully, I'm sure you'll have some questions after we finish on this. Under this new emergency FMLA, the initial 10 days of leave are unpaid. So for 10 days, if they need to go under this, it's unpaid. They may use their accrued PTO, or they may use that emergency paid sick leave if qualified. Remember, they've got 80 hours, 2 weeks, that everybody is eligible, and they can use that if that is a qualified reason for the leave. So they finish with that. Then they go into this new emergency FMLA for the remaining 10 weeks, and they would receive 2/3 of their regular rate, not to exceed $200 per day and $10,000 in the aggregate. If you get to this point, you will be reimbursed this amount for each of your employees that's under the emergency FMLA. So here are your tax credits. It's going to be dollar for dollar credit for all qualifying wages paid under Families First. And those qualifying wages are paid to an employee who takes leave under the Act for a qualifying reason, up to the appropriate per diem and caps, and includes amounts maintaining health insurance. So you're going to be paying health insurance for them all during this time, but that can be a part of that per day amount. You must file a notice of this Families First requirements, and this is the poster. You can get it at dol.gov, and it needs to be posted as soon as possible. So just get it from dol.gov, copy it off, put it on your board with the others. Then you need to implement your policy in your employee handbook, whether that is just Families First, or if you already have an FMLA policy, but if not, you need to do both, your FMLA policy plus your Family First policy. And of course, we have prohibitions. This is just like under FMLA. For those who take paid sick leave, you cannot discharge them, discipline them, discriminate against them for those who take a paid leave, or file a complaint, or institute a proceeding under Families First. So therefore, if you have someone who first goes onto the emergency sick paid leave, then goes into the emergency FMLA, you cannot discharge them. So we were visiting at the very beginning on layoffs. If you know you're going to have to lay off people, it needs to be done before Wednesday. You need to make that decision, but you've got to take in under advisement whether or not you can get the loans. The penalties go under the Fair Labor Standards Act, and it can be up to $10,000 and 6 months in jail. So I don't think you want to be violating any of these acts. So that's the presentation. So now time for questions, and you need to know that things are changing so rapidly. I hope I can answer them for you, but if not, it might be a wait and see. Amy? Can't hear you.
Amy, you need to unmute.
There we go.
Thank you so much, Anne. That was great. Sorry about that. Thank you for all that great information. I know it was a lot of information in a short amount of time. So we have received a few, that's not exaggerating enough. We have received some questions for you. So we've got some time to be able to get through those. If she has not answered something with a question that somebody else has asked that may be similar to yours, please let us know in the chat function along the side of your screen. So with that, I'm going to go with our first question. I think we did cover this, but I'm still going to ask it. I have a question from Kelly James at J&B Industrial Services. Does this bill mean 14 business days of pay or 14 consecutive days off of which the employer will, or the employee will receive pay for 10 business days only? Ann.
The Emergency Sick Leave Act, that very first one, does mean 80 hours, 2 weeks of paid leave for a qualifying reason. And let me say to you, you all are welcome to this PowerPoint, and we'll work with Amy in order to get it. I think Amy will go through the chamber and can go through your email to get it. And it's recorded, so I want to make sure that you get this information in writing, because I know it's hard to assimilate as we run through it as quickly as this. So that first 80 hours, if they have a qualifying event, then you pay them, and you're required to pay them.
Okay, good deal. So my next question is from Ruth Torrens. They have they own Hotel Garza in Post. And she says, we do not have any employees, only contract labor, and most of our personnel expenses are housing, utilities, etc., and provided through the business. Like so many others, our business has come to a screeching halt, and with none for the foreseeable future. I am very concerned that we are going to fall through the cracks on this bill. I appreciate any help you can give us as to where we stand.
If I understand the question correctly, I presume that you have no workers working at this time.
Right.
And with that, what you're going to need to rely on, this bill will not help you because these are for your employees, to reimburse you for employees' salaries. But you will be able to have help with the economic injury disaster loan. You start making applications there. Remember, that is disasterloan.sba.gov. So I would go there, and as well as this new CARES Act that will apply to you at the most. The CH Foundation, I don't know how extensive that is going to be as far as location, but the Jones Foundation and many of those are widespread in the area on who they help. So that might be a help for you. I think your real question was, what do you do with independent contractors? They are not your employees. This is a bill for your employees.
Okay, thank you, Ann. I have another question from Charlene Hack, who works at Bright Star Care. And she is asking, are home health employees, i.e. nurses, caregivers, therapists, home health office personnel, excluded from these acts?
I don't believe that they are. I believe the healthcare professionals definition is just as efficient. We were looking at that very carefully, thinking that the nurses would be exempt and home health care, but I don't believe so. I believe they will be exempt. I mean, they will not be exempt from
Okay.
this particular. So sorry.
That's
So
okay.
you will be able to be reimbursed for them.
Okay. All right, I've got one more question, and then I am not seeing anything in the chat function. If you've asked a question, if you can please post it again. I'm not seeing where anybody has asked anything, but I will look again. Okay, so one more from the emails. Are real estate agents, and this is from Linda Gaither with Westmark Realtors, our real estate agents are 100% commission. Where do we fall in this?
Those are, it depends on how it is structured. If they are your employees, then it will fit. There are regs, and I didn't put it in this one. There are regs on how you figure out what they would make. And usually that commission goes into, if they have a salary at all, the commission is figured into what their base rate would be. But if they are not considered as employees, then they would not fit.
Okay. All right. Okay, so I'm going to take a question from Kelsey Everett, who asked a question 1124. I think we may have covered this already, but I'll ask it again. If you do not have any employees that meet the requirements, is it still required to pay them according to this act?
If they do not meet the qualifications for leave, you don't pay them.
Okay.
You know, they have to be a qualified, they have a qualified reason for the leave as an employee. The 2 tiers.
Good. Okay.
You can always pay them though. There's no prohibition from paying. It's just that you won't be reimbursed.
Okay. Let's see. Paulette Rogers asks, how will our company be reimbursed?
That's a real good question. They say that it's going to go through your payroll. When you pay your payroll taxes, then they make that determination, and the forms are not there as of right now. But they will be getting regulations for us on exactly how you'll be paid. You'll probably be reimbursed way down the line. So just be prepared. That's why these loans for the interim will be so important for you to keep your business going.
So I've got a question here from Kelly. Is there any documentation required for employees to utilize the emergency FMLA expansion?
For the just the FMLA or just the emergency pay, or both?
Well, this asks for the emergency FMLA expansion.
Okay. We do have medical certification under the present FMLA, and I would say yes. The FMLA continues just as it's written, and the only thing they're adding is more employees qualify and the need to be with children in school. Now, the emergency sick leave, that's different because the requirements are different. The shelter in place, the things that we would have, that's different from needing medical certification.
Okay. Got one here. Oops. Sorry about that. If you have any employee that self-quarantines because their family has asked them to, but they have no doctor's order for any of them, do they qualify? Our business can function under a shelter in place.
Did you say that business cannot function or can?
Our business can function under a shelter in place.
I think the standard answer right now is we're going to accept what the employee needs. If they are, some are compromised, and the family's very worried about that. And so that's going to be a case-by-case basis, I believe. But I would err on the side of protecting that employee if they're really, really concerned. Telework works great. If there is any way that they can work from home, have them work from home. But have them realize that this is not long-term. They don't want to, you don't want them to think, well, I've worked from home during this coronavirus issue, and so I can work from home from now on. No, they need to understand that they can work from home, but it's only during this pandemic that we have.
Okay. So,
and you do not pay them under the under these paid leave. That does not qualify. If they work from home, they're working and they get their regular salary. But they do not get reimbursed. You do not get reimbursed for that.
Okay. I'm going to ask one from the chat here. I've got Laura Riley. Have you heard any guidance about how STD, short-term disability, and expanded FML interact? For example, if you have an employee on emergency FML due to child care, then are they picked up on short-term disability?
I doubt they would be picked up on short-term disability for child care, but they would be if they were suffering from coronavirus lasted long.
Okay.
But the answer, I do not know the answer for sure on that. That would be with your short-term disability company.
Alrighty, here, let's see. I've got one that I asked for a screenshot of, but there's several in the screenshot. So, okay. So this is from Heather Cervantes. Does being a nonprofit / tax exempt organization make a difference in this bill?
No, it doesn't. There's nothing to say that they do not participate.
Alrighty. I am going to pull one from my email here. This is from Chrissy Cozart. For salary employees, can we reduce their pay to the 2/3 if they work a half day and be compliant with exempt pay?
Well, let's take it that they are exempt, because you can have salaried non-exempt. So if we have a salaried exempt, the exempt employee rules and regulations federally still apply. So if you have an exempt employee who works during the week at all, you pay them for the full week, pursuant to your PTO plan. They still use that. If you're asking about reducing the wages, if you're going to be under FMLA, I never recommend reducing wages. I think if you're under FMLA, you have a problem with that. Ron, do you have any?
No.
I think I would be very careful in reducing the wages to 2/3 of the amount, but there is nothing that I have read that says you cannot. I think the regulations, when they come out, we'll know more about that. So I would wait before I did any reduction.
And the concern would be for the salary was going below that.
Well, right. The salary people cannot go below the minimum wage, of course, depending on the hours. So exempt people, I'd leave them alone. I'd have them work though. Have them work from home, continue their work.
Okay. All right. I have another question here that want to remain anonymous. If you take out an SBA loan, will you be disqualified from other types of relief reimbursements?
I do not know. That is unknown. The first one under, and I think that you're saying if you go under the economic injury disaster loan and you also want to go under the CARES Act, that's going to be a question for the SBA for you. And Calvin Davis here is in the SBA, and he will be able to help you with his staff as far as the loans go.
And that actually into that, that will be our one of our next webinars that we do next Wednesday at 1 p.m. will be with Calvin Davis and the SBA. An invitation will go out this afternoon for our members to be able to register for that. So keep that in mind, or contact me or visit our website if you have not seen that come across your desk. So we'll do a couple of more questions here. Anne, if you're okay with that?
Sure.
Okay, just making sure. Okay, if you, asked that one already. So just to clarify, you just said we cannot lay anyone off after Wednesday.
You will not be subject to Families First for any employees that are laid off before Wednesday. Once Families First goes into effect, then if they need to be off, you're going to have to pay. The safer method would be, if you're going to lay off, do it before Wednesday.
Okay.
Let them go get their unemployment.
Okay. And this kind of rolls into that a little bit, I guess. Are we able to terminate employees for discipline issues during this time?
No. Because it would be, their claim would be that you discriminated against them and you terminated them because of their taking the Families First salaries. And it would be the same thing as if you were terminating someone during FMLA, because once they will say that it was in retaliation, and you will not get a summary judgment. The nexus or the time frame is too close, and that's a fact issue. So you will be going to court. And so all of us want to, our job is to keep everybody out of the courthouse. So do not terminate during this time.
Okay, I have a question from Kathy Cummings. If you have to send home essential employees due to the 10-person limit, will they qualify for the emergency sick leave?
They have to fit within those criteria, the 6 criteria. And I don't believe, if you look at that, it's not going to be a shelter in, it's not going to be a coronavirus, it's not going to be a healthcare provider send them home. It's not going to be because of their children are there. So I don't believe that that is going to qualify if you need to send them home. Now remember, the 10 people, you can separate people. You might have 2 different floors, 10 on each. You might have separate rooms where they don't gather. You know that you don't want to do that if possible. You would like to have everybody as separate as possible.
Okay, thank you. All right. This is from Ty Rogers. If a business has fewer than 50 full-time employees, but with part-time is well over 50, are they included?
Yes, they are. Under this new act, all full-time and part-time are added together for the number. So if you're looking at trying to get an exemption from that FMLA, you would not be under 50.
Okay. Good deal. All right. What type, and this is from Holly Hasselhoff, what type of documentation do we request from employees to see if they qualify for the leave? Will the IRS require documentation of leave qualifications to get the reimbursements?
It's a good question. We don't know what kind of documentation they are going to require as of right now. That should be coming out in some regulations as they are DOL scrambling to get those done. I would get as much documentation as possible so you can prove that you should be reimbursed, because that's going to be your burden.
Okay, Anne, thank you. All right. So the next question is from Marcia Swank. Would an S Corp with the only wages paid to the owner be considered the employee for this act?
I would have to look at the definition of the employer. It would depend on how many employees they have, I believe. So that could just vary. Wish I had a definitive answer, but I don't on that.
Our next question is from Galen Taff. When do the 10 days of unpaid leave start? During the first 2 weeks or after the first? During the first 2 weeks or after the first 2 weeks?
Would you repeat that, Amy? I'm sorry.
Sure. When do the 10 days of unpaid leave start? During the first 2 weeks or after the first 2 weeks?
The first, under the emergency FMLA, unpaid leave starts the day they leave to go home. Let's say it's a shelter in. And so for that first 10 days, that is unpaid leave under the emergency FMLA. However, the Emergency Sick Leave Act implements immediately, and so that employee can use the Emergency Sick Leave Act for the first 2 weeks and then move into the emergency FMLA. They can also use PTO time if they aren't using the Emergency Sick Leave Act during those 10 days.
Okay.
Now realize that that doesn't mean it has to start April 1st. It might start when they use Emergency Sick Leave Act April 18th. And then those times start running from there.
Thank you, Anne. Okay, I have a question from Amanda Assiter. How does it affect me when I own a hair salon? We had to close on Tuesday and I have 2 full-time employees.
That is a closure that is mandated. I believe that is going to be under Group 1, Number 2. And so they would be able to, you have 2 choices. First, you can lay them off and wait until you can open up again and rehire. You do that before Wednesday. Or once Wednesday starts, you can pay them under the Emergency Sick Leave Act for 80 hours. But after that, it does not roll into the emergency FMLA. So they could do the sick leave and you can make a determination whether or not you're going to pay them or send them home or however you're going to work that.
So Eric Lee is asking, if you are claiming that your business is essential and a shelter in place is mandated, an employee wants to leave after April 1st, that is an essential and does not meet any of the other requirements, are you required to pay sick leave?
If I understand the question correctly, as someone who is essential, they would not have to pay. The emergency, it says the healthcare professionals and the emergency responders are those that do not qualify. So I believe it would depend on the type of essential business that you have. The regs are going to come out on that as well. So it's a wait and see.
Alrighty. I am scrolling down here. We have lots of questions. Pauline is still asking, Paulette Rogers, our company is still essential. Are you saying we cannot discipline an employee that is still working?
Oh, no, I'm not saying that at all. You can definitely discipline your employees. You just can't discharge them during this. Essential that's one that's going to be questionable how far you can go with it. But no, you can. If your employees are still working for you, yes, you can discipline them. They're coming late. You document it. Go ahead and discipline. Let's terminate during this time.
Okay, you broke up a little bit there.
Pardon?
You broke up a little bit there at the end.
I'm sorry. Let's just don't discipline. Let's don't terminate during this time. You can discipline.
I have another question from Kathy. But we have 2 part-time employees, low chance self-exposure, 1 due to travel, 1 due to family members, low risk exposure. We asked them to stay home for 2 weeks just to be safe. Do we need to pay them?
If you ask them to, first you can pay them by PTO time, have them use that. Once April 1st starts, if a healthcare provider tells them to stay home, that's one thing. I think I would try to rely on the PTO time, but you can also pay it. That's your own choice. Yeah, they do.
Okay. And this is from Haley Bird. Can you define the healthcare workers that do not qualify?
The only one that the Act states that does not qualify will be physicians.
Alrighty, sorry about that. So has anything changed on the unemployment pay?
On the unemployment, I'm sorry, the unemployment what?
This is from Wesley Robinson. He was just asking, has anything changed on the unemployment pay? I'm not sure that's being covered right now, so that probably is an irrelevant question. Sorry about that.
No, they can still file for unemployment, and of course you'll be charged for that on your unemployment itself. But it is my understanding that they are going to be moving that very quickly,
Yeah, so that works.
so they'll be paid.
Well, I've come to the end of my questions on my screen. Oh, I just got another one from Kristen Peterson. Kristen is asking, to be clear, if we have an underperformer in July that is not utilizing sick pay nor EFML, are you saying they should not be terminated until January 1st of 2021?
No, that I'm not saying that. I'm saying that if they are under the emergency sick leave or under the emergency FMLA, that is when you don't terminate. It's just like regular FMLA. You do not terminate during that time. But if they're not under any of these, it's business as usual.
All right, I have a question from Brigitte Yeager. Do employees who have self-quarantine need to provide a fitness for duty to return to work?
I think that's a best practice to have them do that. Not required, but I would do so.
Okay. I've got one more question from Amanda Assiter. So her 2 employees already filed for unemployment. Is it preventing her from receiving certain loans or applying?
I think that's going to be a Calvin Davis question next week.
So I've got Amy Sorrells. How do we file for the exemption?
I think you're saying file for the exemption. Do you mean, does she mean how you file to get the reimbursement, and that's going to go through payroll taxes?
Amy, if that didn't answer the question, please let me know in the comments section. Let's see. She was asking for less than 50 employee exemption.
Oh, I'm sorry. Okay, that's going to be through the Department of Labor, and the regulations will tell us exactly how to do it. But I think I would go online to dol.gov and go under the emergency FMLA and read through there, and they should be providing some forms and methods by which you can file for that exemption.
All right. Well, I have come to the end of my questions. I'm going to give it a minute here. If anybody else has any further questions for Ann, if you can ask those now. Oh, we did get one from Laura Riley. What if an employee is choosing to leave their children at home so they can come to work? Is the employer obligated to offer them paid leave as of April 1st, or is it the employee's responsibility to request leave?
It is the employee's responsibility to request the leave, and that they are going to go home and take care of their children.
So Jennifer Johnson is asking to confirm, we can terminate if they are currently working for discipline reasons, just not employees on leave.
Or that is correct, or employees that have taken advantage of the leave. So that would be subsequent to that.
Perfect. Okay. Okay, so I'll give it a minute now. I haven't received any other questions. Let me just check my email one more time and see if I have any there that I may have missed. Did get a question from Sherry Flynn. Are you saying that reimbursement to employers is in the form of tax credits? If so, does that mean an employer that is a nonprofit corporation cannot be reimbursed for paid leave?
I can't answer that question. From the regs, it has not. I think the regs will show that.
Okay, she sent a subsequent email here. Is Ann saying that reimbursement to the employers is in the form of tax credits? If so, does that mean an employer cannot be reimbursed for the paid leave.
It is in the form of tax credits, and how that's going to apply to the nonprofits as well as the public employers, that is not.
All right, I did miss one question here from Holly Hasselhoff. What time of documentation do we request from employees to see if they qualify for the leave?
Well, if it's going to be from their healthcare provider, having them self-quarantine themselves, you need some doctor from the healthcare provider. If they are going to take care of their children, and you know that they have children at home, then I would just have them give a statement to you for your documentation that this is what they're using leave for, and you can use that as your documentation. Of course, the shelter in place, that's going to be self-evident. We know what that is. And if they're going to be taking care of someone who has coronavirus, I would have a doctor's note for that, just but for FMLA if they were taking care of an ill parent or child or spouse.
All right, I have another question here from Eric Lee. Eric is asking or stating, I have multiple retail stores and a separate office. These combined to have over 50 employees, but individually, we don't meet the 50 employee level. Do we add up the employees, or can we be exempt based upon the entity structure?
Well, the way the emergency FMLA is written, it's every employer that has one employee or more. So they're going to add every one of those up. It doesn't matter. They will qualify. Now, if you're requesting an exemption for under, I would use the FMLA qualifications for the amount of the mileage, the 75 miles apart, and say that we really are very, very small. You might have offices with 3 people in Luck, and you might have offices with 5 people in Midland and in different areas. So if I were asking for an exemption from Department of Labor, I would make that argument pursuant to the existing FMLA.
Okay, well, I do not see any other questions at this time. Again, I'll give you guys about 20-30 seconds if you have any questions for Anne. Her email is in her PowerPoint presentation, so I'm sure if you had a question for her, you could email her. I'm certain that's why that's on there. With that said, Anne, thank you so much for being with us today. You have been a trooper in answering questions for the last 30 minutes. Everything has been exceptional. The information was great and clear. I can understand it, so it was very clear, and I appreciate that. If anybody else, like I said, has any questions, Anne, are they more than welcome to email you? I'm assuming, yes?
Yes, they are. I have to qualify that. Right now, it is a very, very busy time. I represent school districts and employers, and we are inundated trying to get our students and our teachers and our employers taken care of. I will make my best effort to get a response back to you, but it might take time. Okay.
And I'm going to say, if you want to, which would probably be easier, if you would not mind emailing me at amy.marquez@lubbockbiz.org, we can definitely get a list of questions to Anne at one time, and then get some answers to those and share those with those of you that ask those questions.
That would be great.
That will be easier. Yes, ma'am. That will be something that we can definitely do. So again, thank you so much on behalf of the Lubbock Chamber of Commerce. We appreciate the Underwood Law Firm, you and Ron Garcia, for providing this presentation today. And with that, I would like to say good day. Please contact us if you as a business owner or employee have questions, concerns, topics for any further webinars that you would like to participate in. Please shoot those to us. We're always looking to see what we can do to help out our members and our member businesses. So have a great day. Stay safe, stay healthy. And Anne, again, from the bottom of my heart, thank you so much for today.
Thank you. Bye. Have
Bye.
a great day.
Have a great day, everyone.